well. Thank you so much.
Oh, you're very welcome.
Thank you, guys.
You take care. Have a good day.
Will do.
Okay, the next case is People v. Christopher Anderson. And Mr. Anderson, would like to be seated over at that side of the
Sir, I'll stand, that's fine, I can stand over here. I would like to state for the record though, I am the principal for that trust. Anderson is my clan name. My given name is Chris, I go by Chris.
Okay.
I do know that I filed the proper common law paperwork within the court here to show that I have a copyright notice over that name that this court is using on that trust. And the court does not have permission and written express consent to use said registered copyrighted trademark trade name.
Well, I don't know why we would use it to begin with, other than to address you while you're in court.
Well, sir, that's why I was addressing the court and giving them the consent to use my name Chris and not Christopher Anderson, as that the court does not have that consent.
Very well. It should be noted that you appeared on the 14th of September, and we continued it until today for a motions hearing, and you have filed the motions, and so...
Well, sir, if I may, this was actually scheduled to go to trial on the 12th of October. However, the court rescheduled it and did not give notice that it was rescheduled. I actually had to call in and find out from the court because I have not received anything in the mail from the court.
I think that you actually did not take your file to the clerk as requested, but nonetheless you were sent notice and you're here today, so we're all set. And your first motion is a motion to demand this court read all the pleadings filed with this court and only adhere to constitutionally compliant law, and more particularly the Bill of Rights in its rulings. You may proceed with your argument on this motion.
So I require a plaintiff to appear in court. I offer remedy to all verified claims. However, the people of the state of Colorado is not a person. I am one of the people of the state of Colorado, and I am not a corporation. I am, again, a spiritual being. I am a living, breathing, live, flesh and blood spiritual being. I am not a corporation or a legal, quote, person, nor am I a surety for one. Therefore, I filed that particular motion also because the last hearing on the 14th of September, you had pled me not guilty. I did not make a plea during that hearing.
No, actually I did not. You objected to that being done, and so I struck that. So you did not plead not guilty. So for the purposes of this hearing, it should be noted that speedy trial has not begun to run.
Okay, and I'm not going to make any plea or plea deals. I am just here to, as the administrator of that account, that I do not consent to this matter, that I am here in special divine appearance only to challenge the jurisdiction and to have this matter dismissed. I believe that the court lacks jurisdiction, as does the prosecuting attorney, and I would like to see the supposed jurisdiction duly placed into evidence. As this court cannot move on facts that are not in evidence, I would like to see where the competent facts witness is and where the damaged party is. I would like to see and face my accuser who brings this claim.
You are basically requesting discovery. That would be conducted once you have entered a plea of not guilty.
Well, we could...
Excuse me, let me talk now. So that is all a part of the process. Do you have anything further on this motion?
Well, I do not understand how this court, in which you denied me last time on the 14th of September, you did state on record that you would not adhere to the American Jurisprudence Book 16 under constitutional law. You said that I had to have it on a motion. You said that you would not adhere to any constitutional law, as I did not have it on a motion. I had requested it in that hearing on that day, in which I could have had this matter dismissed on that day had you adhered to your solemn oath, but instead it was, I did not know that you had stricken it because you never stated that your plea of not guilty was stricken from the record during our last
Yeah,
hearing.
I did, but you were too busy interrupting me to hear it. Anything further on this specific motion? Do you wish to reply to this, Mr. Gregory?
Yeah, I think, first I'd like to acknowledge that under Rules 212 of the Colorado Rules of Municipal Procedure, all motions shall be oral unless otherwise ordered by the court. It's my understanding that the court did ask Mr. Anderson to file a written motion. If the court wants the people's response in writing, I can certainly provide that, but I think our statements orally today will suffice unless the court wants to take it under advisement and ask that the motion be reviewed further. With respect to this motion to demand the court read all pleadings filed with this court and only adhere to the constitutionally compliant law, more particularly the Bill of Rights and its rulings, I guess from the people's standpoint, in all matters in front of this court, I think it's imperative that we uphold defendants' constitutional rights and follow the Bill of Rights. So, as a matter of the spirit of this motion, I only find a few things objectionable. The people do object to some of the statements included in section 4 of this motion, which states in pertinent parts to acknowledge that American citizens are sovereign to this nation, and that government, this and other courts serve the American citizens pursuant to subsection 3 states acknowledge that lack of constitutional authority precludes any action and voids any ruling by this court. I object to the comment or the statement that this court lacks authority or legislative jurisdiction. And I guess generally I can provide some basis of the people's basis for this court's jurisdiction over Mr. Anderson, or whatever name he wants to call him. So it's a little bit confusing to me when reading through some of these motions, because Mr. Anderson does appear to acknowledge the legitimacy of the U.S. Constitution, but then in other places intends to assert his right as a sovereign citizen, which his government doesn't have authority over him. But I will reference the U.S. Constitution generally. This court does have jurisdiction that derives from both the U.S. Constitution, the state constitution, and the town of Breckenridge municipal charter. Under the 10th Amendment of the Constitution, which is recognized by Mr. Anderson, it clearly states the power is not delegated in the United States by the Constitution or prohibited by it to the states or reserved to the states or statutes or to the people. This criminal proceeding happening in the town of Breckenridge is delegated to the people of the state of Colorado. The Colorado Constitution further delegates to the town of Breckenridge the right to establish town ordinances and enforce those town ordinances through its municipal court. Section 13-1-4 of the Colorado Revised Statutes provides that the municipal governing body sits the town of Breckenridge to try all alleged violations of ordinance provisions in such a city or town. Based on the subject site, I asked the court to take judicial notice that this was an incident that happened within the town of Breckenridge, and that this court thereby has the authority and the jurisdiction over this matter.
I wish to respond.
Yes, I do, sir. In regards to their requesting this be a verbal motion to the court. I would request that the courts disallow that, as the courts disallowed me to make any verbal motions. I would like line for line, each one rebutted per motion, and I would like them on paper. That way I have them for my own record, in which I can properly allege and or propose a defense against that. Secondly, with regard to the town ordinance in which the prosecuting attorney brought up, I would like the court to see on the same motion, I believe, the stare decisis of Marbury versus Madison, in which specifically states that I am, quote, I am next to consider such injuries as cognizable by the courts of common law, and herein I shall, for the present only remark, that all possible injuries whatsoever.
I ask you a question, was Marbury and Madison criminal or was it civil?
That was in 1803, that was brought up as a criminal case.
Was that the case? My recollection was, I believe it was civil, was it not?
Yeah, it was between
Two states, but it was not a criminal matter. You see, a lot of as a general rule, if it is criminal, one, criminal matters are statutory. Civil matters are between two individuals, corporate or personal. So Marbury versus Madison was not a criminal matter. We're dealing with criminal matters in this case, and thus it is not really appropriate as authority in a lot of your sites. Also, it should be noted that my guess would be Marbury and Madison was 1803. It's now 2023. My guess is that there have been cases between now and then which probably modify it and change it. I don't see any updated sites.
Yes, Your Honor, there is no updated sites, because in over 200 years, that case has never been overturned. That case has been cited thousands of times in both state and federal courts and has never been overturned.
It is simple.
Then I would like the courts to recognize Rodriguez versus Ray Donovan, which is a criminal case in 1985 that states all codes.
Rodriguez versus Ray Donovan, that is civil once again.
I guess the people would just say, with respect, if we are talking about Marbury v. Madison, that case just stands for the proposition that the Supreme Court does have jurisdiction, appellate jurisdiction, to interpret the Constitution itself. It's a fundamental case that dealt with things that were not criminal. It was a case in which the respondent in that case was challenging the jurisdiction of the Supreme Court, and the Supreme Court ruled in Marbury v. Madison that the Supreme Court has appellate jurisdiction expressly under the U.S. Constitution, and the jurisdiction of this court and the legitimacy of the federal courts, the state courts, and the municipal courts does derive from Marbury v. Madison, but it doesn't stand for whatever proposition Mr. Anderson raised.
Well, I would also like to bring to the court's attention too that we're talking about the people of the state of Colorado, which is considered a corporation that you are trying to attempt to bring in against an actual
This
people.
is a criminal matter. This is statutory criminal. It is not civil. And many of your sites go to civil cases which are really not appropriate, aren't binding on a criminal matter.
And again, we're trying to bring a corporation against a living, one of the people of this state of Colorado, which I actually brought in the other day and filed a cease and desist order to prove that I am not a fictional corporation. I am a living spiritual being born on dry land.
That.
And that's why I asked that I need to see who brings this matter, because the people cannot bring this matter. They are not an injured party. There must be an actual injured person party for this matter to be a criminal matter against.
And that would be brought out in a trial and finding of fact.
Again, so that would mean that as of right now, that Mr. Gregory over here, the prosecuting attorney, is standing in place under fraudulent pretense to bring this matter against one of the people of the state of Colorado, which constitutes as constructive fraud. That is a violation of both fiduciary duties within this court as trustees.
The fraud whatever fraud Mr. Anderson is speaking of is a constructive Mr. Anderson's imagination. He's asking us to point to laws that just establish what the law is. This derives from the U.S. Constitution, the state of Colorado Constitution, and the municipal charter of the town of Breckenridge. If he wishes to disregard the authority that we're citing, I'm not here to actually convince Mr. Anderson anything other than that there are laws that have established the authority of this court and this body and the right of me to represent the town of Breckenridge and the people of Colorado.
Again, you speak of the town of Breckenridge.
Let him finish.
That's fine.
Well, initially on this first motion, the court will note that I've read everything, read the whole motion. I am following my judicial oath. We are looking at all the matters that you have cited are civil, and this court has been established by the U.S. Constitution, the state constitution, the Colorado legislature, and then further the town of Breckenridge Town Council. We are dealing with statutory law, not civil law. As far as the court having jurisdiction over you, service was made over you by the issuance of a summons and complaint. And the due process that you are talking about is what is provided at a trial.
I've not been served anything for this matter or this case, so I don't understand what the court is talking about.
You were issued a summons and complaint. That summons and complaint was issued on the 23rd of June.
I've not received anything.
You were served it. The officer swore that you received it.
I would like to say that is fraudulent. I have not been served anything from this court in any part of this matter.
You were served by a police officer, not by the court.
Again, I would like to go on record and state that there has not been any service made for any part of this matter by any police officer, sheriff, which is required to be a sheriff if I'm to understand the law correctly under you guys' state laws. It's supposed to be a sheriff.
Understand all of the law correctly. It would probably be in the best interest to hire an attorney, but I would doubt you would be doing that. It should be noted that at a trial, when you're asking for specifics, that is what a trial does, and the people have the burden of proof, which is beyond a reasonable doubt. It should be noted that you did cite Boyd v. U.S. That was a case settled 140 years ago. Gould v. Gold that you cited is over 100 years old. Watson v. Memphis, which is again a civil case, is not applicable. West Virginia State Board of Education versus Barnett is an 80-year-old case and once again is civil in its nature. In going through this, the court finds that most of your sites are at least 100 years old. They have probably been modified or adjudicated. Do you wish to address the fact that they're that old?
I would
The fact
like
that they're civil or this is a criminal matter?
the fact that whether or not they're civil or criminal has and should have no relevance, as the Constitution of the United States specifically states that, and I'll go to with what the prosecuting attorney brought up under the 10th constitutional amendment, that right belongs to the people. Me being one of those people, I hereby take away any authority that this court may think that it has over me, along with the, and I quote again, the prosecuting attorney stating the town of Breckenridge being the person that was injured in this party. Again, they cannot be an injured party. I did not injure the entire town. The entire town of Breckenridge is not here right now to stand in defense. Neither is the entire people of the state of Colorado. In fact, I, being the only sovereign individual from the state of Colorado, from Colorado State, here present in this courtroom, I'm the only authority in this courtroom in which to move on any matter that is brought before this court. Therefore, I request again that this court dismisses this case and this matter, as I am not a corporation or a legal fiction in which they are attempting to put me down as. I am a spiritual being. I am born alive in Colorado State, which I have established in this court. I would like to see where the individual known as Town of Breckenridge and the individual known as the people of the state of Colorado, where were they born and where are they? Who brings this matter before the court except
You wish to
for...
respond to this, Mr. Gregory?
You know, I don't really know what any of that means. To the extent that Mr. Anderson is requesting that we respond to the comment that nobody was injured in this matter, the state constitution provides the town of Breckenridge with the authority to adopt a municipal court to hear and try all that violation injury to the town of Breckenridge. Mr. Anderson is alleged to have committed an ordinance violation within the town of Breckenridge. That's the injury. Section 2.2 of the Breckenridge Town Charter establishes Section 8.2 of the Breckenridge Town Charter establishes the judiciary within the town. This matter is appropriately within this court. If Mr. Anderson wants a person, I am that person. I am representing the town of Breckenridge and the people of Colorado in this matter.
So you were personally present at the accident and the incident, and you can actually attest for the state of Colorado what happened during the matter, because as I know, you were not there.
I've been appointed by the town council, who has the authority to regulate matters within the town of Breckenridge pursuant to the Breckenridge Town Charter, which has authority under the state constitution, which has the authority under the U.S. Constitution. So for the purposes of that question, yes, I am.
I would like to call to the court's attention that constitutes high treason, as he cannot be the injured party.
Excuse me, I think you're throwing around terms that are not appropriate and not accurate.
Again, though, he's
Will
not...
deny your motion.
I guess I would just like to say that real quick. Mr. Anderson, you do have rights that are established by the U.S. Constitution. Your right to liberty it cannot be abridged without due process of law. You are experiencing the due process of law currently. There is nothing that has been done to this point in time, or will be done in the future that is not compliant with that principle. You are afforded due process. That's it. You have certain rights established by the U.S. Constitution, but those rights are not unlimited. You're being provided the due process you're required.
The court, they're actually violating and failing due process, again, because the rules, codes, and laws that were established by my fellow man without my consent do not apply to me, and I did not consent to any of your town ordinances. I choose to voluntarily follow your laws. I choose to voluntarily listen to your ordinances, in which, as a sovereign individual, as an American state national and not a U.S. citizen, I do not have to adhere to any of those laws. Those laws are not compliant to me. I voluntarily choose to, because I follow God's law and natural law, and that is all. In which, again, you've already brought forward stating that you are the injured party under the town of Breckenridge and the people of the state of Colorado, which
you are mistaken on that. He represents the town as the prosecutor. The victim in this would be the individual that was involved in the disorderly conduct and the assault. There is, and that matter is, would be determined at a trial where you would be provided due process, and well, it's interesting. I'm sure you researched all of this, and I'll ask you questions about it as we go through, and I'm certainly that you'll be able to tell me what the case is about.
Well,
if I ask that.
Just to clarify for the record too, Your Honor, that you stated that he was not, he did state specifically that he was the victim in the matter. So I would like to, yes, he did. It was on record, sir.
Not.
He did.
No, he did not.
So I do not understand.
The victim, should the case go to trial.
But I don't see his name as the one of the people that is versus me. It was the people of the state of Colorado. So why is it not Bob Gregory versus Christopher Anderson if he is the
If it were Bob
representation?
Gregory versus Christopher Anderson, that would be a civil matter. This is a criminal matter.
Well, I bring remedy to all verified claims, in which this is not a verified claim. They still not yet show or bring anything from the facts and evidence where the competent facts witnesses.
The facts and witnesses would be presented at trial. At this point, you are presumed innocent. And as the trier of fact, I would not be given those facts until they come in at a trial with the witness being under oath, following the rules of evidence, and you would be allowed to cross-examine each witness, place your own version of what occurred in a trial. That is what due process is all about. Now we'll move on to the motion to dismiss with prejudice.
So
Do
before
you have
we
anything further to add from your motion?
Well, I would like to clarification, because I do not understand the fact that you just denied my first motion when the prosecuting attorney, Mr. Bob Gregory, just stated on record that he had absolutely no problem with the approval of that, with the exception of one specific paragraph. And again, I requested on record that the court, before they issue any determination on any of my motions, that those be put down in written form, not under verbal, as I was required to put it down on paper. I would like the state also to put it down on paper. That way I can properly address each line for line and as to why in another motions hearing. Before the court denies that, that is a failure of due process, in which I have requested, the court mandated me to do it. Therefore, I am requesting that the courts mandate the state to do the same as well.
Can you respond to these motions in writing?
I certainly can if the court If the court is requiring a response in writing, we're happy to do it.
Okay, how long will it take you to respond in writing?
By the next court date.
Okay, so we will continue this matter to the 9th of November.
And
Does that give you enough time?
I think so. I mean, if Mr. Anderson wants time to respond.
yes, please.
Okay.
Set it up for everybody.
Okay, why don't we continue the hearing to the 14th of December for the hearing with the motions or the reply brief to be done by the 9th of November. And since speedy trial is not running,
How would the court like us to provide that, our response to Mr. Anderson? Should we get it to the court?
yeah, I guess that would be probably the most efficient. The court will have the reply brief by the 9th of November. That is when we have court. You can come in by noon that day and get the reply briefs, and then the hearing will be set on the 14th of December. Do you have any questions on any of that?
Along with that, since they're asserting jurisdiction based on, the people of the state of Colorado and also the town of Breckenridge, I would like that in the motion too, as far as, not necessarily discovery. I don't need the entire discovery of the case. I just need to know who the competent facts witness is, who the damaged party is, and who brings the claim and who is underwriting the action.
There is a process that is followed. You have not entered your pleas on any of these charges. It would be my understanding that discovery of what you are asking would be provided after you have entered your pleas and the case is proceeding. Would that be correct, Mr. Gregory?
I believe so, although, I don't object to, for providing Mr. Anderson with a copy of
The police report.
the report.
Okay.
Well, I have the police report, but that, again, that's a police report. That's not actually who brings this matter to the court. Because
Mr. Gregory, Mr. Anderson, the police report is what the people have control over at this point. That is what is sufficient. Now you're just, you've got a copy of the police report, is that correct?
the police station has
Is it yes
provided,
or no?
has provided a copy of the report in which happened that day. So if the police are gonna be present, all of the officers that were there, and they are the injured party, then I suppose I don't need further, validation as to who brings this matter, because again, I believe that it's under constructive fraud that,
It's not
they are
constructive fraud.
bringing this against a person, a corporation.
One, it's not constructive fraud, it's not treason. You should probably choose your words a little more carefully, but that is your choice. You have a copy of the police report. Do the people have anything further than that?
Well, I think regarding Mr. Anderson's request, it sounds like what he's getting at is he wants the right, the opportunity to confront the witnesses against them and cross-examine the witnesses against them. That's exactly what the trial is for. So if and when we get to a point where a trial is scheduled, the people will present the witnesses, against you in this matter, and you will have a right to cross-examine those witnesses. That would include the police officers, that would include Mr. Rodriguez, the driver of the other vehicle in this matter, and any other witnesses, that you will bring in front of the court. Mr. Anderson's constitutional right is the right to cross-examine those witnesses, and he will be afforded that right.
And I've also given this court to caveat on that. I believe it was on the 8th of August, roughly, this court was provided a rescission or an affidavit of rescission, in which everything was taken away from this court as far as any contracts that I had entered with this court unknowingly and unwittingly. That would include the police ticket in which was signed. It was rescinded. This court did not file within 21 days a rebuttal, and or the prosecution did not file a rebuttal, so that stands as truth in commerce. And so I would also like to know where the contract and the 1099 OID is for this matter. I would also like those brought into or been presented to me as well, because again, with that rescission, this court does not have jurisdiction over any of this matter, as I rescinded everything with a contract that was unrebutted to the people of the state of Colorado and to within this court, and nothing has been provided to deny that or line for line rebut anything within that.
Are you aware of any of that?
I haven't seen that filing. I don't know what you're talking about.
I haven't seen that filing either, and it should be noted that your initial court date was the 10th of August. You failed to appear. We sent a letter for compliance, and then on the 14th of September, you appeared, refused to, did not enter a plea, and the matter was then set for this date. So,
if I may really quick, Your Honor, I have the actual copy in which was filed to the court here, and it's also been filed to the clerk and recorder's office for the state of Colorado. So it is on record both in this court and also with the state of Colorado on record that I did file this, the affidavit of rescission, and nothing has been responded to within the required 21-day time period.
interesting in looking at the filings in the court file.
In fact, I have a copy of it in my vehicle.
Well,
I have the original, I should say.
I see a notice of rescission.
That would be what I'm referring to. That is my affidavit of rescission, in which was not rebutted or responded to within the 21-day time frame.
I would review it now.
Sure.
Lots of response.
There you go. I don't see a filing stamp on that.
You mean with a date stamp? Is that what you're referring to?
Yes.
Again, I have the original in my truck because it was stamped with the red Town of Breckenridge stamp from the clerk's stamp upstairs. I made sure I got a copy of that because I recorded it with the state's clerk and recorder's office to make sure that it was affirmative on record that after 21 days that is truth in commerce, and that has not been rebutted to, and it has not been, nothing has been done with that. And so that stands as fact and truth.
I guess just generally the people's response to this is that this notice of rescission has no legal merit or basis with respect to the criminal proceeding. this court and the jurisdiction of this court doesn't require consent of the defendant. To the extent Mr. Anderson is rescinding his consent to these proceedings.
I'm sorry, but I don't understand that because
There's no merit to that notice. But people certainly don't recognize it.
and I don't understand why the court would entertain that, as again, they had 21 days in which it was filed, which I've provided everything filed, and I've also, everything that has come to this court has been subsequently filed as registered mail as well, so that way I establish common law jurisdiction within this court, and the court is still operating under admiralty law and contract law, which again, I've established common law within the court in the matter.
Of course, the matter, you're citing common law. This is statutory law that we are dealing with. All criminal violations are statutory. They're not common law. And so common law really has no bearing. The rules of the municipal rules of procedure are the governing rules for this court, with some guidance from the rules of Colorado rules of criminal procedure. So what we are dealing with at this point is our next hearing on this matter will be on the 14th of December. The people will file their response to your motion on the 9th of November. If you will please take this to the clerk, she will give you a filing notice as to the hearing on the 14th of December. Once again, that will be at 11 a.m. And the matter will be taken up at that time. Now, I will ask the security person to take this with you to the clerk, and she will give you your notice for the next court date. I already have that notice. You provided me with the date. No, you don't have that notice because we just made that on the record, and we will give you a paper notice of that hearing date.
Okay, so I don't understand how this court can still operate under admiralty law when I've established common law within this court. I don't understand any of what's happening in this court right now because again,
explained to you that we're operating under constitutional law. I don't know what you're even talking about.
and again, you're operating under contract law.
No.
If you want somebody to explain it to you, but it's not.
We're not.
People will put it in writing, and I will provide a response by November 9th. If you want to then decipher it, decode it, and still argue that we're operating under admiralty law or any other kind of law you want to argue, you certainly can after that date. But to the extent you don't understand it, it's not my job to make you understand.
I think it's you guys that don't understand that this is common law, that we are in the United States of America. We are not on the high seas right now.
Excuse me. Common law has no bearing on criminal law. This is a criminal action.
Okay, and
It's governed by statute.
common law can govern both criminal and civil matters.
Interesting proposition. Has little bearing in this case. Cameron, if you'll please take this file with Mr. Anderson and tell Maddie that we need to set this for a motions hearing on the 14th of December. It's written down there.
So to take to the front, take it to Maddie.
Take it to Maddie.
Okay.
Yeah. Maddie will provide you with a notice on that.
And really quick to ask for the court, being indigent and also under Title II of the Americans with Disabilities Act, being a disabled vet, do I need to set a motion or file a motion in order to get the transcripts from this hearing and also the last hearing so that I could submit those to the 10th Federal Circuit? I'm asking as far as being indigent. I know usually you have to pay for transcripts.
To prove that you are indigent, and we can have a hearing on that on the 14th of December also. You'll have to fill out the form.
Okay, and I can get that form from the clerk of the courts upstairs?
Get it from the clerk.
Okay, and then do I need to put in a Colorado open records request in order to get the bar license numbers of everybody within this court so that I can file the proper documentation with the 10th Federal Circuit and also with the Uniform Commercial Code?
I don't think that falls within the realm of discovery. Your feeling on this, Mr. Gregory?
There are certainly processes Mr. Anderson can file to get the information he's requested. I don't believe it's within the process of discovery that's afforded with this particular case, but he's certainly willing to do his own research or hire an attorney to advise him on how to do those.
Well, attorneys are injurious to freedoms and liberties of anybody, and I think we've established that here today.
Well, you know, the thing about it is, in one of your pleadings, you allude that you're not held to the Colorado Supreme Court has held that if you represent yourself, you are held to the same expertise level as an attorney.
And I understand what the Colorado Supreme Court has stated, and to go on or with that, instead of asking or the court recommending an attorney, I would like advisory counsel appointed from the court.
You'll need to, first of all, file, we'll have to determine your indigency level, and that will require that you fill out the form, swear to it, and then we deal with that at a hearing. So you may do so, and this hearing is closed at this time.
Okay. What's that?
We're gonna file this.
Right there. Sorry.
I believe she's over here.
I did not have there was another table down here.
It's a little big. In that there's a new court date.
Yeah.
So.
Okay, so I've got this all written out for you. It has the new court date, and then it has on the bottom written about the prosecutor's response. So are you planning on coming in to pick up the response in person, or?
I can try and be in here in person. I know that they're required to have it done and ready by the 9th.
November 9th,
Yeah.
yes. And so if it's after that date, that's okay too. Otherwise, I think the mailing address that we have for you is not correct.
It should be. It's on top of every motion that I've filed with the
Okay.
court.
Can we just get a copy, or can you just write it down for me, just so we can make sure that we've got the right mailing address? I've just got that, and that's the form that he would want.
For indigency? Okay.
But then, yeah, all the information about the prosecutor's response is on the bottom.
Okay.
And I will mail it to you as well, but just in case it doesn't work out, if you don't receive it, you can come in here and pick it up.
Okay. Thank you.
Thank you.
Have a good day, man.
Thanks, you too, man. Can I get out there?
You should be able to.
One way or another?
Yeah.
Uh-huh. Nope, you're fine.
Drive safe, man.
Yeah, thanks.